Perhaps one of the most fraught questions in the area that we're looking at, the area of precedent, relates to the right of the Court of Appeal to depart from a judgment of the House of Lords. Now, this is linked to a second question, the question of whether the Court of Appeal is bound to follow its own previous decisions. I want to look at a couple of cases in this area. I want to deal with the first point, the relationship between the Court of Appeal and the House of Lords, before turning to the second point, i.e. the question of whether the Court of Appeal is always bound to follow its own previous rulings. So, tensions had indeed developed between the Court of Appeal and the House of Lords, and this takes us to the case Schorsch-Meyer, decided in 1975. The two cases that we're going to look at, or the two main cases that we're going to focus on, Schorsch-Meyer now and Davis and Johnson in a moment, take us to the work of one of the most interesting, creative and innovative of modern judges, Lord Denning. And so this first case that we're looking at, Schorsch-Meyer, is when Lord Denning was in the Court of Appeal. He makes the following argument, and again it takes us back to the Sterling damages rule and the House of Lords ruling in Havana Railways. Lord Denning in the Court of Appeal argued that circumstances had changed so much since the House of Lords ruling in Havana Railways that the Sterling judgment principle should no longer apply to the Court of Appeal. Now, this obviously goes against the doctrine of the hierarchy of the courts, but Lord Denning, who's master of the rolls at that point, stated that the underlying reason for the damages being in sterling was essentially a practical reason. He went on to argue, to make an argument from principle. The principle that he evoked has a Latin tag, a Latin name, which I will now try and pronounce for you before giving you the English. The principle that Lord Denning is referring to in Schorsch-Meyer, in other words, the principle that underlies his argument that the Court of Appeal should be allowed to depart from the House of Lords, is the principle cassante ratione legis cessa ipse or ipsa lex, or, as he pithily puts it in English, seeing that the reason no longer exists, we are at liberty to discard the rule itself. Lord Denning's argument, as elaborated, really rests on the following point. It would be wrong to abrogate proper rights, substantive rights, by reference to procedural concerns. In other words, what he's saying here is that it would be wrong for the Court of Appeal to be bound by the House of Lords on this point about sterling damages, because the rule itself no longer applies. In other words, we are abrogating, we are denying litigants the substantive right to take their damages in a different currency on purely procedural grounds. It's almost like the argument I was trying to outline earlier on, that the demands of justice in an instant case, in a particular case, may justify departure from the rules. Now, obviously, this is a massive argument, isn't it? It's if we were to follow through Lord Denning's argument, then the Court of Appeal, which normally has to follow the House of Lords, would become a much more powerful court. The counter-argument, of course, is that would disturb the hierarchy of courts and lead to inconsistent or incoherent development of the law. The House of Lords, of course, were not particularly happy. Their response to the case Schorsch-Meyer in the Court of Appeal came in the Miliangos case that we've already looked at. Now, obviously, in Miliangos, when we looked at Lord Wilberforce was saying it's appropriate for the House of Lords to depart from its own previous judgments. It's not appropriate for the Court of Appeal to suddenly depart from the House of Lords. Lord Simon, in the Miliangos case, with the explicit agreement of Lord Wilberforce, rejected Lord Denning's cassante ratione argument, i.e. the argument that the Court of Appeal was at liberty to depart from the rule because the reasons for the rule no longer existed. So Lord Simon, with the agreement of Lord Wilberforce, explicitly rejected this principle. He argued that the wide meaning of the principle would mean that any court could, quote, disclaim any authority of a higher court on the ground that the reason which had led to such a higher court's formulation of the rule was no longer relevant. Lord Simon went on to say that application of this principle would mean that the court could even overrule Acts of Parliament if it judged that the reasons for the rule no longer applied. As such, the rule has, quote, no place in our modern constitution, close quote. I think what we can see from what Lord Simon is saying, that Lord Denning's argument simply isn't acceptable. It goes too far. In a sense, it is too creative. It creates too much of a disturbance within the hierarchy of the courts. In other words, it would have been correct for the Court of Appeal to wait for the House of Lords to change this rule. It was not correct for Lord Denning in the Court of Appeal to make some kind of argument that it was right for the Court of Appeal to depart from a binding precedent, the Havana Railways case, which held that the Court of Appeal should give damages in sterling. However, Lord Denning didn't stop there. This takes us to our next point. Now, this next point, as I suggested a little bit earlier on, concerns the question of whether the Court of Appeal could depart from its own previous decisions. In other words, we're turning to a related but different point. The Miliangos-Schorschmeyer point relates to the House of Lords. The point that we're now thinking about relates to the Court of Appeal. The major case that defines the law is a case called Young and Bristol Aeroplane, decided in 1944. This states that the Court of Appeal is bound by its own decisions unless, firstly, is the Court of Appeal decision given per incuriam, or in other words, with the omission of very important legal considerations or what have you, which makes the decision flawed. That would be a ground to depart for the Court of Appeal, to depart from a previous decision of the Court of Appeal. Or secondly, it involves an earlier conflicting decision by the Court of Appeal, which the Court of Appeal may then, and then the Court of Appeal, I beg your pardon, may then choose which case to follow. If there are two conflicting decisions, the Court of Appeal can choose which case to follow. Thirdly, the earlier Court of Appeal decision has been expressly or impliedly overruled by the House of Lords, or to complete that, by the Supreme Court. These are relatively narrowly drawn instances when the Court of Appeal can depart from its previous rulings.